Welcome back to Time Served, the channel that puts in the work so you don't have to. And today I have an early drop for you nerds. In the 36th District, in courtroom 339, Judge Bryant had a pre-sentencing hearing where every wheel of justice was in high gear. And Judge heard from the victim, the defendant, the attorneys, and Mr. Gray, the victim, made some very valid points, although will technically not affect the sentencing because there are limitations due to it only being a misdemeanor. It had to have played in Judge Bryant's decision as to the extent of the sentence for Mr. Knudsen. Mr. Gray makes claims of race, where if the shoe was on the other foot, the outcome may have been different. After listening to this hearing, tell us what you think by letting us know in the comments. Don't forget to like and subscribe and set your notifications to all and never miss any content throughout the day. So without further ado, let's roll, nerds.
Mr. Knudsen, state your name for me. Unmute, Mr. Knudsen.
Yes, it's Christian Appleby Knudsen.
Knudsen. I knew it. I was thinking that. And then I said, did I make that up in my own mind that it was Knudsen? But no, you said Knudsen. That's what it was. And I was going to say it, but I went with the other thing. So anyway, Knudsen. All right. So today is the date set for sentencing. The court has had an opportunity to review the pre-sentence report. And with respect, with respect to the report itself, are there any additions, deletions, or corrections on behalf of the people?
Judge, the people had an opportunity to review the pre-sentence report. I don't see any additions, deletions, or corrections at this time.
And are there any on behalf of the defense?
Judge, Mr. Knudsen and I reviewed this report. And Christian, I would ask you to verify that there are no additions, deletions, or corrections to the report that we reviewed. Am I correct?
That's correct, Mr. Holmes.
All right. With respect to sentencing, then, is there anything on behalf of the people?
So, Judge, I do have the complaining witness here via Zoom this morning, and I would defer to Mr. Gray if he would like to make a victim impact statement. But before I get to that, Judge, just noting that I see there was a recommendation for 9 months of probation from the probation department. I'll leave it in the court's discretion whether to take that term of probation into consideration. However, Judge, I'm looking at the substance use and treatment section on page 6. And just looking at the history provided by probation and seeing where Mr. Knudsen is placed today, I believe that would address the people's concern for some type of drug treatment program. So at this time, Judge, I'll leave it in the court's discretion if the court would like to do some type of mental health evaluation, just looking at the history and the comments on page 5. But other than that, Judge, I'm sorry, on page 6. But other than that, Judge, I would turn over to Mr. Gray if he would like to make a victim impact statement for the court this morning.
Mr. Gray, would you like to make a statement to the court?
Yes, ma'am. I'm just totally really pushed back and baffled and disappointed in the way this is turning out. And the reason I'm saying this, I'm just a man trying to go to work, take care of my family to the best of my abilities and abide by the law. I am so heated right now. I'm serious. I'm just being honest. I am so heated right now as a man that I took the high road. And this guy is about to get a slap on the wrist, but 9 months probation. If I, a man, me, being a black man, if I would have even touched somebody, I would be facing years. If I knew this was going to go like this, I would have took a totally different route and beat the brakes off this man. This man took his hands and grabbed my stuff for no reason. And put my stuff in a vice. I'm still having pain up to this day. I done lost over $50,000. $50,000 because of this guy being an animal. Keep trying to just grab my private parts because he's a homosexual. And I don't play that. And I kept asking the man, don't do that. Stop. Don't do that. And when the police finally came, they were sitting there for 15 minutes. It took them 30 minutes to get 15 minutes to get there. And when they was there, they sat there for 15 minutes while I'm battling with this guy, trying to keep him from grabbing my stuff. You know how much strength it takes to hold a person and fight them off for 30 minutes? It's exhausting. And then when the police finally came, I was hollering for them. They just sitting there looking. And then when they finally came, guess who they treated like they was the criminal? They treated me like the criminal, hollering at me. And this guy, and started putting on the Karen Act, crying, and they treating me like I'm the damn criminal. They treating me like I'm the criminal. I never seen nothing like this before in my life. I am so disappointed. I had even wrote the police department a letter and gave it to them, and they just looked at the letter, shaking their head about the conduct of how these officers act when they got there. They hollering and screaming at me and pick him up like he's a victim and take him to the damn ambulance. Excuse my French. I'm just here.
Let me say this, Mr. Gray. I don't mind you making a statement, but you can't use profanity.
That's why I said, excuse me, ma'am. I didn't mean that. I really didn't mean that. I don't have no disrespect for you, the court, or anybody in this courtroom. I'm just upset because I'm trying to do the right thing, and this guy's getting slapped on his wrist. If I look at a woman the wrong way or look at somebody the wrong way, they're gonna want to throw the book at me. That's all what I'm saying. I just can't believe this. I can't believe this. Man, I wish I wouldn't even be looking at you right now. I'm telling you. Because you make me want to seriously hurt you.
No, Mr. Gray, we're going to be respectful. I'm sorry for what you've been through, but
I understand. They want to respect me now, but when I was getting hurt, I wasn't getting respect.
Mr. Gray, I wasn't there when you were getting hurt.
I understand, ma'am. I'm sorry.
So
that's all I got to say. That's all I got to say.
All right.
That's all I got to say. No disrespect to you, ma'am. I apologize. But as a man, you probably can't understand how I feel.
Well, I can't because I'm not a man. I've never been one, and I don't ever want to be one.
And I understand that. Ma'am. There's no disrespect to you, and of course, I'm sorry, but I'm just saying, for this person to be sitting up here in my face like nothing has happened, it's ridiculous. And the charge that he's getting charged with is ridiculous. This guy needs to be on the sex offender list. He really needs to be on the sex offenders list. Because this ain't going to do nothing but escalate. What he's doing ain't nothing but escalating. And I'm telling you, I guarantee you, this stuff is going to come back one day where he's going to do something even worse. He's an animal, a predator, a criminal, and anything else to go with it. You have no idea of what this guy used to do with this building. And he's been getting away with it for years. That's all I got to say, ma'am. That's all I got to say. Thank you for letting me voice my opinion, my concerns.
You're welcome. Mr. Coleman, anything on behalf of the defense? Ms. Silman, I need you to call them back. I need you to call them back.
Okay, Judge.
Thank you. Anything on behalf of the defendant, Mr. Knudsen?
Yeah, Judge, and certainly I wasn't there. So this is a very, when I read the report, I was disturbed. I was upset. But I live in Detroit. And when you say, and I shouldn't go off on this complaining witness because I've been there, done that, seen it. Other people in this community attacked So when you say you to be in jail, I don't think so, sir.
Well, Mr. Coleman, I don't want you
Well,
to.
I'm gonna leave it alone. I'm sorry, Judge.
You're directing your
I'm gonna get away
comments
from
to
that.
me. You're
Yeah,
directing.
I'm sorry, Judge. I apologize.
All right.
You know, but I'm just anyway. This person, my client, has a drug problem and has had it for years. And clearly, he is done by way of the pre-sentence investigation. He's taken steps not only to get out the community, but to rehabilitate his life. Now, some people have mercy, some people don't. I'm asking for the court's mercy. I understand that the anger of the complaining witness, but clearly, Mr. Newton has a drug problem and has had it, it looks like, virtually all of his adult life. But now he's in a inpatient substance abuse treatment. He's been there for the prior 9 months. He got out of the way he was living, the city he was living in, and in fact, removed himself to another state where we hope he's doing the right thing. So I would ask the court to adopt the recommendation of the sentence report and provide another chance, as we do for a lot of people.
All right. And would Mr. Knudsen like to make a statement on his own behalf?
Sure, absolutely. I a lot of thought into what I wanted to say this morning. And first of all, I want to apologize to Mr. Gray. Sir, it was a confluence of very bad circumstances that this happened in. Judge, I was being held on the ground for 30 minutes. And when I reacted to that situation, I was simply, I think, emoting how horrible it was to be held on the ground by 3 men. And so this was not done in any kind of sexual way. It was done, I think it was almost an instinctual response to that situation. Now, that being said, you know, Mr. Gray and I were friends, actually. Not friends. We were quite genteel with each other. And when this happened, I did attempt to apologize. I did attempt to say that I'm sorry for this situation, and he would not have it. I have put so much work into my sobriety. I've been sober over 15 months now. I've really turned my life around. I left Detroit. I got the heck out of there. I'm living in Asheville, North Carolina right now in a sober living where I'm surrounded by really good people. I get drug screened, you know, at least every week. I'm actively searching for work, and if we just be honest, you know, I was the one who was taken to the hospital. My nose was broken. And I feel like the situation will be rectified by this. I accept the consequences for my actions for hurting him, and I would just like to beg for your attention to the pre-sentencing investigation, and hopefully this matter can be resolved.
Okay, thank you. Good morning, Mr. Morgan.
Morning, Your Honor.
Mr. Morgan, thank you for coming. I actually just realized that Mr. Knudsen is living outside of the state of Michigan. And so he's not going to be eligible.
Okay.
So thank you, though. But I have a question for you since you're here.
Yes, ma'am.
I had another. Would you be the person that would also interview if I needed someone for, oh wait, no, that's not the person. They're not here yet. Okay, never mind. I had somebody I wanted to refer to sobriety court, but they're not here yet.
Okay, Judge. Yep. If you need me, I'm available.
Okay, thank you so much, Mr. Morgan. You have a great day. Stay safe.
You too. You and your staff. Take care.
Okay, so the court has had an opportunity to review the pre-sentence report. I'm ready to impose sentence, and I'm going to do so after making a few observations. So first of all, I don't know. I don't know what was explained to Mr. Gray. However, no one should ever presume what I'm going to do. Nobody should ever presume what I'm going to do. I don't come to work to rubber stamp anybody. No, nobody. Right? That's number one. Number two, Mr. Gray's statements and his feelings are valid. They are valid feelings. Now, his anger may be misplaced, but his feelings are valid. And we live in a society, unfortunately, that on many occasions, law enforcement makes assumptions about people of color. And when they arrive to the scene of a place, they make assumptions about people of color. So we're not going to downplay the fact that when the law enforcement arrived to the scene, that they may have perceived Mr. Gray to be the aggressor, because it happens in too many occasions. It happens too often. Now, the anger that he feels with respect to the place that Mr. Knudsen finds himself in today, facing this court on the misdemeanor docket, is misplaced towards the court. And I don't even know if he expressed any frustration towards Ms. Ritter. That would be misplaced as well. So obviously we know that the Wayne County prosecutor elected to serve the citizens of Wayne County is the individual who makes the decisions with respect to what a person is going to be charged with. Now, I'm almost 100% certain that Madam Kim Worthy did not make the decision specifically on this particular case, because there are individuals who work in different units of the prosecutor's office who make charging decisions. They make those decisions, I believe, and I don't know for sure because I've never officially worked for the prosecutor's office outside of doing an internship in law school. So I believe that they make those decisions in consultation with the police, or at least with respect to the information provided to them by the police. So the frustration that you feel, and while you did say you wrote a letter to the police department, the letter was probably better directed to the prosecutor's office. So the prosecutor's office makes the decisions about how an individual is going to be charged. And the reality that we face at this very moment is that Mr. Knudsen was charged with a misdemeanor. Mr. Knudsen's crime is punishable by only 93 days in the Wayne County Jail and up to $500 in fines plus up to 2 years probation. That is the reality that we sit in this morning as I decide what sentence I'm going to impose against Mr. Knudsen. So while you may be correct, Mr. Gray, that had the situation been turned around, you would have been charged higher. So you may be correct. I don't know. You may have been charged with a felony. Mr. Knudsen has not been charged with the felony. Nothing I do today is going to send Mr. Knudsen to prison. Nothing I do today is going to send Mr. Knudsen away or put him on probation for 5 years or 10. Nothing that I can do today. Why? Because my authority under the law does not allow it. So your anger about how it's being handled, it is valid. It may be valid. It may be valid because we feel how we feel. but it is misplaced. It is misplaced. The individuals on this screen have not made any decisions with respect to how Mr. Knudsen is going to be charged. In fact, as we sit here today, Mr. Knudsen pled guilty as charged. There was no reduction in his charge. There was no reduction. Miss Ritter didn't make any special accommodations in terms of her negotiations. There was no deviation to a disorderly person. None of those things occurred in this case. However, he has pled guilty to the maximum thing that he was charged with, and that is assault and battery. So, with respect to that, that is how we will proceed. Now, Mr. Knudsen, your actions were deplorable. You admit in the pre-sentence investigation that you used racial slurs. You admitted that you broke windows, and then you admitted to assaulting Mr. Gray. Now, I'm not sure, again, why the prosecutor's office chose to charge as they did, but they did, and it's their right and it's their prerogative. And therefore, okay, that's another discussion. All right, so it's their right and it's their prerogative. So I'm looking at page 4 where he admitted to breaking the windows. I don't know whose windows he broke. I don't know what windows were broken, but there's no indication about any restitution for the windows in the pre-sentence investigation. So I don't know whose windows were broken. Then I also noticed in the pre-sentence investigation, and by his words today, meaning Mr. Gray, it appears that on some level there was some situation medically, I guess. However, on page 4, he did indicate that he did not go to receive any medical attention, and therefore anything, I guess, relating to that would have to be resolved if there was any civil litigation that came out of this situation. So, Mr. Knudsen, I was happy to read in the pre-sentence investigation report that you have taken strides to address your sobriety, but your lack of sobriety, your voluntary lack of sobriety is not an excuse for what you did or what you may do. So the voluntary lack of sobriety, now I know people say medical, whatever, at some point in life, there was a movement to label alcoholism as a disease. I know that that's what medical documentation say. And I'm not a doctor because I don't like blood and stuff, so I couldn't go to medical school. So I don't understand the inner workings of the body. But it appears to me that alcoholism is a voluntary state that people put themselves in. And then maybe because of their genetic makeup, maybe because of, whatever genetics and things going on in the body, maybe that's what then triggers, their inability to stop. So I don't know. And I don't want to know because they make you, you have to draw blood and stuff when you go to medical school. So we're using that as an excuse as to what occurred. I don't know if people get stronger or weaker when they are intoxicated. I remember when I was growing up, when we had alcoholics in our family, I remember them being easy to tackle. I remember them being easier to tackle. Like if your drunk uncle came to the family reunion, you just you know, it was easy to make them sit down because they were drunk and you could knock them down. This doesn't sound like it was so easy to hold down Mr. Knudsen. And that's why I don't know if it was because you were drunk or not, Mr. Knudsen. It sounds like there was an intense struggle going on. But again, I'm not a medical person. I don't know. And I didn't ask any of my friends that are doctors. I didn't ask them. But this is where we find ourselves. So I was going to attempt to refer Mr. Knudsen to the specialty court based upon page 6 under the mental health portion of his report. Additionally, the top portion of the substance abuse use and treatment portion of the report, I was very surprised that under the needs, they indicate that the needs plus recommended intensive outpatient treatment, but then on page 2, there was no recommendation for intensive outpatient treatment. So that confused me a little bit. Nonetheless, I am going to accept the recommendation from probation for probation, but not for 9 months. So I'm not accepting the recommendation for 9 months. I am going to impose the following terms of probation. And the probationary period is going to be for 14 months. I'm going to impose a 14-month probationary period. Now, of course, according to Michigan law, that means that Mr. Knudsen would be eligible for early discharge after the halfway point if he completes the terms and conditions of his probation. So a 14-month probationary period would put us at September of 2024, and then we'll do Friday, September the 20th, if the matter goes to the conclusion of the 14 months. That would be September 20th, 2024, with the following terms and conditions. You shall not violate any criminal law of any governmental unit. Now, I don't remember if I gave you permission to reside in North Carolina. However, if I did not, I am now. You may continue to reside in North Carolina. However, you cannot leave the state of North Carolina without consent of this court. You're not free to travel about the country. You have to stay in one place so we know where you are. You are not free to leave the state of North Carolina without consent of the court. You must notify probation immediately of any change of your address, phone number, or employment status, and you will pay the following fines, costs, and fees. I don't have my probation orders right in front of me. Oh, here we go. Yes, I do. All right. You will pay $210 mandatory costs. You will pay a $400 fine. There was no request for restitution. The court sets restitution at this time at 0. You will pay $35 per month supervision fees for a total of $490 for the entire 14 months. If you get discharged early, you won't be responsible for the supervision fees, for the supervision fees that would have come. If you've already paid, we will reimburse you. If you have not paid those fees in full, then we will just waive them. Court is going to impose a $35 pre-sentence investigation and substance abuse evaluation fee. The total fines, costs, and fees Mr. Coleman, were you retained or appointed?
Retained, yes, Judge, retained.
Court is going to impose $1,135. In order to be discharged early at the halfway point, you would have had to pay $890 of that in order to get discharged in 7.5 months. Sir, as a condition of your probation, you shall not use or possess any illegal substance. You shall not use or possess any marijuana. You shall not use or possess any opiates without a valid prescription and letter of explanation from the doctor as to why they have prescribed such an addicting narcotic. You shall not use or possess any alcohol. I know this is not an alcohol case. However, everything that is in this report indicates that Mr. Knudsen is blaming alcohol and or narcotics on his behavior. Therefore, he shall not consume any alcohol in any form. He shall not drive without a valid license. You shall attend or you shall submit to a mental health evaluation. You shall continue in outpatient treatment until the court determines otherwise. You shall attend a 12-step program at least once a week. You should have no contact with Mr. Michael Anthony Gray. You shall pay any outstanding tickets that you have. According to this report, you don't have any. You shall not drive without a valid license. I don't know if I said that already. And according to this report, at least your Michigan license is not valid. You shall submit to random urinalysis once a month. Now, let me be clear. I know how much it costs in Michigan to get drug tests. I know how much it costs in the city of Detroit to get drug tested. I don't know how much it costs in North Carolina to get drug tested. But if the North Carolina drug test is $150 a month, that's not my business. The Michigan drug test is like $20 a month, $35 a month, depending on what you get. If their drug test is $150 a month, that's not my business. What I'm saying is you have to submit to your analysis. Now, I do understand that the program he's currently in, he says he's submitting to your analysis. I will accept that, your analysis, but he would have to sign a release so that they could send those results to the probation department. Please understand, Mr. Knudsen, that probation is the alternative to jail. Jail is the alternative to probation. Clearly, Mr. Gray wants you to go to jail. I don't believe in putting people in jail right away on misdemeanors. Again, Mr. Gray, that's the fact that it was charged as a misdemeanor is an issue for Kim Worthy. That's an issue for Kim Worthy. But it was charged as a misdemeanor. But let me just indicate, we can't use alcoholism and drugs as a reason why we were being derogatory towards a person. Out of the abundance of the heart, the mouth speaks. What's in my heart is what comes out of my mouth. If I'm under the influence of narcotics, I'm not going to start calling you names because that's not what's in my heart. That's not what's down on the inside of me. If I'm drunk, if somebody, because I'm never going to be drunk voluntarily. So if y'all see me drunk, know somebody put something in my drink and call the police. That's what I'm telling you. Okay. So I'm never going to be drunk voluntarily. But if somebody causes me to get drunk, I'm not going to start calling them names. I'm not going to start using racial slurs and demeaning terms because that's not what's in my heart. So I can't change a person's heart on probation. I can't. We try to change lives in courtroom 339, but it's nothing I could do about what's in the abundance of your heart. But I hope that your road to sobriety and the things that you will learn in the 12-step program, I hope those things will change your heart. Because if you're admitting to saying racial things towards Mr. Gray during this situation, that's what's in your heart. That's out of the abundance of the heart. The mouth is speaking. As we think, that's who we are. Things we thinking about, that's who we are. So those are things court can't change, but life experience can change, right? So I just hope that you never find yourself in this situation again, Mr. Knudsen, and Mr. Gray. I hope you never find yourself in this situation again. I can't apologize for Mr. Knudsen, and I don't know if you accept his apology, but I don't believe anyone should go through those types of situations. And I don't know what I would do if someone was hurling racial slurs towards me. I don't know what I would do. So it appears that Mr. Gray did take the high road. I wasn't there. I don't know what happened. Only the two of you really know what happened. And even in that, the two of you knowing what happened, your perspectives are different. Your perspectives are different. Somebody might have said something and you took it one way and they meant it another way. So people's perspectives are different. So just remember that going forward in life. But I do just want to make clear that probation is the alternative to jail. Jail is definitely the alternative to the probation. And therefore, I am expecting you to complete the terms and conditions of your probation. I'm going to give you a halfway review date. And if you have completed the terms and conditions on this date that I'm going to give you, you will be eligible for early discharge. Eligible for early discharge. Eligible for early discharge. That doesn't mean it's going to be, but you're eligible. So if we haven't had to pull teeth and do whatever, then you may get the early discharge if you have completed the terms and conditions of the probation. 1, 2, 3, 4. The halfway point is February. Let's go with February the 23rd, 2024 at 10 o'clock a.m. Now that's when you come to see me, Mr. Knudsen, but please understand that you're obligated to check in with probation on a monthly basis. You're obligated to check in with probation on a monthly basis. Sir, we are going to mail a copy of the court's order to the Asheville, strike that, to the Spears Street address. Probation is going to contact you at the phone number ending in 7151. Ending in 7151. Again, I'm going to state, I don't know whose windows were busted out, but that was not a part of the request, or, I mean, they mentioned some windows being busted out in the precinct's report, but no one attached ownership to that or nor requested any restitution for that. So right now the court has set restitution at 0. Anything further for the court?
Judge, just very quickly, there's an anger management, 12 weeks of.
Oh, I apologize. And I'm so glad you said it verbally, because I would have been fussing at him about that anger management because I checked it on my paper, but obviously I didn't say it out of my mouth. So yes, Mr. Knudsen also has to attend 12 weeks of anger management. And I don't know if eBay is still doing their anger management virtually. So this is what I want my order to reflect. I want him to do the anger management with Mr. Rice's program through eBay. That's what I want. But if Mr. Rice is no longer doing his classes virtually, then probation can work with Mr. Knudsen to find an anger management program in North Carolina that is acceptable to 36 District Court. So it has to be approved. You can't just go do your own, because let's be clear, other than Mr. Rice's program, other than Mr. Rice's eBay program that I know works and that I know he actually is conducting, that's the only program I allow online right now. That's the only virtual program I allow. So you can't go sign up for some online anger management. I'm not going to accept it. It has to only be Mr. Rice through eBay, and then another program that is approved by 36 District Court that kind of follows along with what Mr. Rice does. The program has to be 12 sessions, not one 12-hour course. When you're doing anger management, you have to go to the class, get some information, and then see how that works out in the real world, then come back to the class and talk about it. That's how anger management works. Okay, but thank you for saying it out loud, saying it, because I clearly hadn't said that as a part of my order, and I had written it down.
And Judge, finally, there's a 771 that looks like he's eligible.
Yes, and I will sentence him under the delayed sentence statute.
Thank you again, Your Honor.
You're welcome. Anything further?
No, thank you, Judge.
All right. Then we're all set. Mr. Gray, have a great day. And Mr. Gray, I'm going to say to you, I can clearly see you're angry, and I might be too. So I'm not indicating that you don't have a right to be, but I just want you to work on that anger, because it brings so much devastation on the body. Anger does. Anger and a lot of stuff. And so don't get a hernia being mad at Mr. Knudsen or the police and stuff. Don't do that. Your family needs you. You're working out there. You're trying to take care of your family. If you feel a way about this, again, I know you said you wrote a letter to the police, but perhaps a letter to Kim Worthy would be appropriate, even though we've already done the sentencing, so that she could be aware of your feelings. Okay. All right. Everybody have a great, oh, you're talking, but you're not unmuted. You're muted, Mr. Gray. That's okay. You're good. All right. Have a great day. Stay safe.
Thank you, Judge. You too.
You're welcome. You're welcome, and thank you.